Good day, ma'am. I am Hanah Purgarillas from BSHM 3A, and I am going to discuss Chapter 3, Law on Obligations and Contracts. Before that, here's the topic outline: the law, discussion of the law, obligation, classification of obligation, modes of extinguished obligation, contract, characteristic of contracts, and classification of contracts. So in the end of the topic, here's the learning objective. First, identify the different kinds of obligation and contracts. Enumerate the ways of extinguishing an obligation. Enumerate possible applications of contracts in the tourism, travel, and hospitality industry. The law on obligations and contracts. A person engaging in tourism, travel, and hospitality industry must enter into agreements and contracts, giving rise to obligations. Understanding obligations and contracts helps prevent legal disputes and ensures compliance with laws governing business transactions. Obligations definition. Article 1156 Civil Code of the Philippines. An obligation is a juridical necessity to give, to do, or not to do. It is a legal duty, and failure to fulfill it can lead to a legal action. Elements of an obligation. First is active subject, the party who has the right to demand fulfillment. Second is the passive subject, the party who is obliged to perform. Third is object or prestation, the act or thing to be given, done, or not done. Last is the juridical tie, the legal bond that connects the parties and enforces compliance. Types of obligations. Obligations to give a determined thing. The debtor must deliver the specific item, take care of it with diligence, deliver its accessories, and pay damages in case of non-fulfillment. Obligations to do. If not performed, it will be completed at the debtor's expense. If done improperly, it will be redone at the debtor's expense. If poorly done, it must be corrected at the debtor's expense. Sources of liability: fraud, intentional deception to avoid fulfilling an obligation. Negligence, carelessness leading to non-fulfillment. Sources of obligation, Article 1157 Civil Code. Law imposed by legal provisions, contracts created through agreements, quasi-contracts arising from voluntary acts, acts or omissions punishable by law, criminal actions creating liability, quasi-delicts, civil liability due to negligence without a prior agreement. Classification of obligations. Primary classification, Civil Code. Pure and conditional obligations. Pure obligations are immediately enforceable, while conditional ones depend on an event. Obligation with a period depend on a specific time frame. Alternative and facultative obligations involve choices between multiple prestations. Joint and solidary obligation. Joint obligation divide liability, while solidary obligations make each debtor fully liable. Divisible and indivisible obligation based on whether obligation can be partially performed. Obligations with a penal clause include penalties and non-compliance. Secondary classification, Civil Code. Unilateral and bilateral obligations based on whether only one or both parties have obligations. Real and personal obligations. Real obligation involve delivering things, while personal ones involve actions. Civil and natural obligation. Civil obligations are enforceable by law, while natural obligations rely on moral duty. Next, legal, conventional, and penal obligations. Legal obligations are imposed by law. Conventional obligations arise from contracts, and penal obligations involve penalties. Modes of extinguishing obligations. Article 1231 Civil Code. Payment or performance, fulfillment of the obligation, loss of the thing due if the item is lost through no fault of the debtor, condonation or remission, voluntary forgiveness of debt by the creditor, confusion or merger when the rules of debtor and creditor merge into one person, compensation when two parties offset debts, novation replacing an obligation with a new one. Other causes of extinguishment: death if the obligation is personal, unforeseen events preventing fulfillment. Contracts definition. Article 1305 Civil Code. A contract is an agreement where one party binds himself to another to give something or render a service. Essential elements of a contract: consent, agreement between parties; object, the subject matter; cause, the reason or purpose. Characteristics of contracts: mutuality, cannot be unilaterally modified; autonomy, parties can freely agree on terms; relativity, binding only on parties involved except when benefiting third parties; consensuality, contracts are valid upon agreement unless the law requires formalities; obligatory force, legally enforceable once entered into. Classification of contracts. First, relation to other contracts. Preparatory, establish conditions for future contracts. Accessory, exists only with a main contract. Principal, stand alone. Accessory, exists only with a main contract. Second, perfection, consensual, perfected by mere agreement. Real, required delivery of an object. Third, form, common, no specific form required. Special, require specific forms. Fourth, purpose, transfer of ownership, example, sale. Conveyance of use, example, comodatum. Redemption of service, example, lease of services. Fifth, subject matter, things, example, sale. Pledge, service, example, employment contracts. 6. Nature of obligations. Unilateral, only one party has an obligations. Bilateral, both parties have reciprocal obligations. 7. Cost, consideration. Onerous, involves compensation. Application in tourism, travel, and hospitality industry. Contracts and obligations are essential in hotel bookings and reservations, airline ticketing and travel agency agreements, tour package contracts, employment contracts in hospitality, insurance for travel and tourism businesses. Understanding these legal concepts ensures compliance, protects business interests, and fosters ethical transactions in the industry.